So some of the pieces of a very basic estate plan include powers of attorney. And there are essentially two different kinds of powers of attorney that you should have. And these should be updated about every 5 years or so to account for changes in the law. The first is a medical power of attorney. This is a document that allows those you have chosen to make medical decisions for you if you are incapacitated. And so you want to make that decision ahead of time of who's going to be making those medical decisions for you. So a medical power of attorney will name those, we call them agents, will name the agents or the medical decision makers for you in the event of your incapacity. The second type of power of attorney is a general power of attorney. And this is the same type of thing except for financial matters. This is the document where you name the agents who will be able to get into your bank accounts and sell your assets and deal in your finances in the event of your incapacity, death, and not death. Let me go back to that. So the general power of attorney will name the agents who will take care of your finances in the event of your incapacity or your absence. Of course, you don't have to be incapacitated for someone to have a power of attorney for you. And so allows other people to take care of your finances for you. And then there's a living will. So there's a difference between a will and a living will. A living will is a medical document. This is the document that names the agents who will make the pull-the-plug decision for you. So we call a living will the pull-the-plug document. And this means that you get to name the people that will make the decision to pull the plug because there's just no chance for your recovery. You're living on a breathing machine, feeding tube, and you're brain dead. So you get to name the people who will make that decision. You also get to give medical directives to your medical providers and to your agents as to what circumstances you do want the plug pulled. So everybody should have a living will. This avoids the Terry Schiavo situation that we saw in Florida a number of years ago. And then we have a will. A will is the most basic estate planning document. It is the document that names who the executor of your estate is going to be. It is a document that names how you want your property to go and to whom you want it to go. A will, however, does not avoid probate. So if you only do a will and you don't do a trust, that will have to be submitted to the probate court and will have to be probated.